Welcome to Sidebar with Judge Dan Winslow. I am Judge Dan Winslow with the New England Legal Foundation, previously with the Massachusetts Trial Court. Sidebar is a show about interesting topics at the intersection of business and law. And today we're going to be talking about mediation. We're really lucky to have two experts in the field of mediation, Superior Court Judge, now retired, Karen Green, as well as Vincent Pisegna, an attorney here in Boston. And I want to welcome both of you to Sidebar and ask each of you to just introduce yourself to the audience. So I'll start with you, Karen Green.
Okay, well, I am a retired judge, as you know, but before I was a judge, I was a litigator for 25 years. And it's my pleasure now to mediate and serve as a neutral in cases.
Fantastic. Thank you, Karen. And may I call you Karen?
Yes, of course.
All right, fantastic. I go by Judge Winslow just for the show because I always, when I stepped off the bench, I was happy to get my first name back. And Vince, could you just introduce yourself to the audience?
Hi, Dan. How are you? Good afternoon. Vince Pisegna, practicing law for 45 years, all litigation. I've tried over 50 cases, managing part of my firm for a while. I was the head of the Board of Bar Overseers appointed by the SJC to regulate the 60,000 lawyers in Massachusetts. That's a big job. And I've done a lot of trial work. I've done a lot of mediation, and it's been fun.
So you regulated 60,000 lawyers, Vince. They're herding cats. So the mediation is pretty easy then after that. Okay.
Yeah, it is not. Regulating 60,000 lawyers in Massachusetts, you can imagine how hard that was. But it really brought a lot of perspective to the dispute resolution process, because we had to discipline when necessary, and that required an awful lot of due process, including findings of fact, conclusions, and what have you.
So I should have added, Dan, that when I was in private practice at a global law firm, I also headed up the litigation department. So I'm familiar with herding lawyer cats.
So you each have had very distinguished careers, and you both have come to the same point in your journey, which is you both are professional mediators. And I'm curious, I'll ask each of you this, why are you a mediator? You could be at the beach right now and, or playing golf or just relaxing, but you've chosen to become mediators. Why? What was the path that brought you to this journey? I'll start with you, Karen.
Well, I've seen conflict from all kinds of perspectives as a lawyer, as a judge, and even at one point as chief of staff to a governor. And I think I've come to appreciate that, particularly in business disputes, which is what I specialize in, alternatives like mediation and arbitration are often more efficient and cost effective, and provide parties with more options in terms of alternatives for resolution. In addition, when parties are dealing with confidential or sensitive business information, it offers confidentiality, which you do not always get, as you know, as a former judge, in a trial session.
And how about you, Vince? What brought you to this path in your journey professionally?
My partner used to say, he was also a litigator, he used to say his real skill was problem solving. And what I've discovered over the years, I think I'm pretty good at it too. And I really enjoy helping people solve their problems. Having done mediation for a while, it's amazing to me how important it is to try to deal with lawyers for the parties who are doing a good job. They're doing a good job for their client. But sometimes the service of their client is inconsistent with trying to reach a fair resolution of a case so that the parties can move on with their life and their businesses. And I would like to give back and try to help people resolve those disputes in an amicable way.
So Vince, Karen had mentioned, arbitration and mediation. Could you just sort of as a tutorial, what's the difference between arbitration and mediation?
In arbitration, you choose somebody, usually a senior lawyer, to act basically as a judge. There's fact finding, and the judge will basically render a decision. In mediation, there is no decision to be rendered by the mediator. The case reaches resolution only if the parties consensually agree. So that's a key difference.
And mediator's role really is to facilitate negotiation between the parties.
And Karen, I'm curious, lawyers have an ethical duty of zealous representation within the bounds of the law, and so I've often heard lawyers say, well, we don't want to talk settlement because that'll make us seem weak. How do you get parties comfortable with the concept that reasonableness or resolution doesn't necessarily equate to weakness?
Well, I think one way you do it is by getting the parties talking about what they're really interested in and what really they hope to accomplish going forward. Because at least in my experience, which sometimes happens in litigation, is that people get so fixed in their positions that they lose sight of their client's interests. And sometimes the client isn't always good at communicating to their lawyers what their real interests are. And one of the good things about the mediation process, I think, and I don't know, Vince, if you would agree to with this, is that often interests become apparent, sometimes even in private caucuses with the client's counsel, that the counsel wasn't even aware of.
Yeah, absolutely. I mean, mediation, we'll talk about this a little bit later, is a tremendous forum for figuring out what's going on both sides of the case, from both lawyers' perspectives. As a practitioner, what I used to say to avoid the problem of appearing weak by suggesting mediation, I would say something along the lines of, the judge is going to order us to go to mediation anyways. So let's do it and get it out of the way so that we can proceed apace to a trial if necessary. Because most judges do. They can't order it. They don't have the power to order it. But if the judge suggests you go to mediation, you'd be foolish not to do it.
So I want let's say, recognizing that every mediation is different. I mean, I've been in mediations where we would have an opening statement at the beginning, but in one case the parties were just so hostile and personally, there's such an animus between the parties that we decided not to even put them in the same room to start off. No good would come from that opening statement or that shared dialogue at the very beginning. We went right to separate rooms, but recognizing that there are those sort of tweaks that you customize depending on the situation. Walk us through your approach to mediation. What are the steps that one does to get from A to B in a mediation? And if you differ in your approaches, I'd be interested to hear why.
I think the first step is you have to get the parties to agree that they want to do the mediation. I don't know, Vince, what do you think?
Well, I think, yeah, that's certainly true. I got a call the other day from a lawyer who says, are you willing to mediate this case? And do you have time? Blah, 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 blah. And I said, sure, of course. Now I know what has happened. He's now talking to the other attorney to see if the other attorney is agreeable to me acting as mediator. So you're right. They don't really get to us for mediation until they've agreed. But I do think, Dan, most mediators, and I know Karen does this too, good mediators, will have a pre-mediation conference with the attorneys. Sometimes you do the attorneys together. Sometimes you do them one at a time. I prefer one at a time, but mediators have different preferences. It's in that call that I think you really shape what the mediation is going to look like, including a decision as to whether the parties are going to make, the attorneys are going to make opening statements. And I don't know how you feel about this, Karen, but I think it's a mistake for an attorney not to make an opening statement. In the business context, people are rational business people, and sure, feelings come into it. But I think as long as you're not dealing with a divorce situation or a personal injury situation, it's a business situation. So I think it's the opportunity for the lawyer to speak directly to the other party that the lawyer is not going to have ever, quite frankly. You're going to depose the other party. That's a hostile situation. And you're going to go to trial, which is also not a very friendly situation. But in a mediation situation, you're across the conference table in a lawyer's office. You can really talk to the other side and in a way that I think could set up what your strategy is going to be in the mediation. So I think that's one of the first questions, Dan, that you want to ask yourself.
Just have a pre-mediation conference. Do you do that as well, Karen? A pre-mediation conference?
Pre-mediation conferences always, but I tend to do them with both counsel, at least at the outset, so that I think people sometimes are more comfortable that way. On the question of opening statements, I'm struck by how often, particularly when the sides are really hardened in their positions, the lawyers will say, let's, in the pre-mediation call, let's dispense with the opening statements. And, you know, occasionally I say, fine. But I have to tell you that the more I mediate, the more I think that maybe you dispense with opening statements by the lawyers, but I would not dispense with a joint session in which people answer the question, what do you hope to achieve today? Or tell me what's really brought you here.
You know, as part of that, yeah, as part of that mediation joint conference, do you also have or receive from the parties respectively their mediation briefs or some sort of a summary of what they think the case is, their strengths, their weaknesses?
I always ask for confidential mediation briefs. Usually people prepare a modified version of something they've already prepared for the court, and then add to it sort of statements they want to make in confidence about what their client would be willing to do. It's interesting to me how often one side decides not to submit one, because I think it's a bad idea not to submit one when you know that the other side is submitting one. I don't know. What do you think about that, Vince?
I think, yeah, I think most of the time, in the 90 percentile, people submit statements. The question in my mind as the practitioner is, do you disclose it to the other side? Is it a confidential submission to the mediator, or is it something that you disclose to the other side? And that's an interesting calculation. You know, if you're a business trying to resolve a dispute, if the damages to be sought in the case are clear, then maybe you don't need to disclose your position to the other side. But if you got any kind of complexity, any kind of 2 or 3 different elements, you want to get your numbers out there, because otherwise you waste a lot of time communicating factually what the damages are, what the claims are. And if you can communicate the numbers in writing, I find that to be an effective technique on both sides, quite frankly, in business cases where there's any kind of complexity in the damages. But no, I agree, Karen. You know, you've got to get that statement, and it's a key piece for the mediator to read.
I agree with you on the point you make, but I think more often what I'm seeing are cases in which the parties have already done that for the court. And so you're getting kind of you're getting that again, together with some information they'd like to keep confidential.
So both of you suggest not waiving arguments of the opening statement, at least, I shouldn't say argument, the opening statement, but you each have received a mediation document, a mediation summary of some sort. So who's really the audience for an opening statement? It's not the mediator. You already know what the case is about from reading the papers. Is it really to communicate to the other side what their perspective of the case is about? To teach the other side?
I think it's both. What do you think, Vince?
I think it's to communicate to the other party. As I alluded to earlier, the lawyers talk about the case for a long period of time before it gets to mediation. Usually, although I hope we're going to talk about early mediation at some point. But in any event, the lawyers kind of know what the case is. The parties don't know. The parties know what their lawyer has told them. They don't really know what the other side is looking for or where they're coming from. So, Dan, I pitch it when I'm a practitioner to the party sitting across the table, because he or she has never heard my pitch from me. And I think there's some real value to that from both sides.
Hey, I'm going to pull on that thread, by the way. What is early mediation?
Go ahead, Karen.
Well, I think of it as mediation before the parties have really even oftentimes conducted any discovery.
Just to get in really early, as soon as there's a dispute, maybe even pre-suit mediation or early in the days post-suit?
You can do pre-suit mediation. The cases I tend to get these days are cases where they're already in litigation.
Right. That's the most common timing of it. I like to get into mediation after the complaint has been filed. because you can say what you want about what your client's claims are, but until you file the complaint in court, you don't know really what they're going to be pursuing. So I think after the complaint is filed, it maximizes the potential for a resolution in my mind if the lawyers say, before we start spinning the legal meter on this case, let's see if we can solve this problem. Let's bring in an experienced mediator, and let's see if we can mediate the case before we start spending money, as Karen said, on discovery and depositions and the like. And there's a real premium to that. Karen, we talked about this the other day in our pre-conference on this podcast. I'll give my pitch. I mean, the first, not to bury the lead, the biggest benefit is you don't spend thousands and thousands and thousands of dollars on legal fees preparing discovery in a case. But there are other more subtle benefits too. What happens in a case is that once you start going into discovery and taking depositions, the positions of the parties harden. And sometimes it's harder to get back to a more neutral setting to get the parties to keep their minds open towards a fair resolution as opposed to hardening their position in response to the other side. So I think there's a real benefit to considering strongly, your corporate counsel, you get served with a complaint, you're going to know a little bit about what's going on in the case. And in this day and age of emails, the facts, most of the facts as well. Everything's in an email, really. You're going to miss some of the internal emails on the other side. And yes, you would get that in a litigation situation. And yes, there's a benefit to that. But really, you got to do the trade-off. Do you really know what's going on? And before we really start banging in discovery, do we want to get the parties together and see what we're really fighting about and see if we can resolve this early? I think there's I'm a big fan of it.
It's interesting. When I started practicing law back, in the days of Moses, there was this concept called nuisance value for a case. And the nuisance value of a case would be $5,000, $10,000, $15,000 maybe. Nowadays, nuisance value, which is basically, will it cost more to fight or settle? It could be $50,000, $100,000 in a business case, could be hundreds of thousands of dollars, just without any regard to merit. You're just going to spend that much. The cost, the transactional cost of litigation now is so high that early mediation angle might make some good sense, particularly economically. So before you've spent the nuisance value for the case, maybe put that money initially, at least, into trying to resolve the dispute.
I agree. And sometimes it's easier to get people to come to a resolution when they're not angry that they have spent tens of thousands of dollars.
Right. Exactly. So after the opening statement happens, basically at that point, is that when you separate into breakout groups and sort of speak to each of the parties separately and confidentially?
Yes.
And as I understand it, mediation is a confidential process, but you have to obtain the express agreement by one party to share with the other party something that they've shared with you in private. Is that the understanding?
I generally ask them to tell me if there's anything they've told me in this session that they don't want shared.
So sort of the default is share unless you say not to. So here's my question.
Dan, if I can.
Go ahead, Vince.
There's confidential and there's confidential. So confidential means you can't ask a question in a deposition, something along the lines of, well, you said during our mediation 2 months ago that A, B, C, D. You can't do that. But what you can do is, very well what they said in mediation. You know what the parties' positions were in mediation. You know the assertions that they made factually. You can take discovery on that. You have the knowledge about what their position is. You have the knowledge of those facts. So yes, it's confidential. You can't disclose what took place in the mediation session, but you have the knowledge and you can use that as a fulcrum to get some formal discovery to actually establish those facts.
I wonder if that's a pitfall of mediation, that people use it really as just a preview of coming attractions for discovery and not in good faith to try to resolve the case. But where do you see each of you for mediations that don't resolve in settlement? Where do mediations tend to break down if there's any commonality about it?
I think it's when people are getting overly emotional. And when there are relationship issues separate and apart from the business issues. I don't know what you would say.
Well, yeah, no question about that. I had one recently where multi-parties, a lot of different lawyers, and the lawyers who were really into the case and litigating the case wanted to mediate it. But there was a lawyer for one of the parties from Maine, and he didn't understand the case. But he was aggressively advising his client to keep litigating. So sometimes you get a lawyer who you're just not going to be able to convince. And I find sometimes lawyers like that really get in the way of settlement more than not when it doesn't work.
Yeah. Have you had experience with a kind of lawyer or an engagement of lawyers called settlement counsel? Have you ever seen or heard of lawyers that are not engaged to litigate the case, but separately engaged just to discuss settlement of the case?
When I was a litigator, I had a couple of cases where I was brought in to see if the matter could be resolved.
Yeah, Vincent, have you had that experience?
Not so much. No, because your leverage as an attorney is, we're going to go to court. So if you're really just there to settle, I think you lose a good chunk of your leverage. So I mean, in my experience, I haven't seen that.
Yeah, I've seen lawyers, and it seems to have gotten more common now than when I started practicing. But clients hire lawyers because they can't work it out themselves, and usually in the past, lawyers should be dispassionate, obviously advocates for their client's position, but dispassionate about it, not emotionally invested in the case. And yet sometimes lawyers just get so personal about some of these things. And my only experience was I was once engaged as settlement counsel. The case settled, by the way, easy case to settle. But the lawyers just personally hated each other so much they just couldn't have any reasonable. These guys couldn't agree on lunch orders, let alone resolving this case. And so it's interesting to see, because sometimes there's the thought in the business community that lawyers have almost an economic conflict of interest with business clients, which is, lawyers get paid mostly by the hour, and so inefficiency rewards lawyers, whereas efficiency is how you make money in business. I'm curious what's your experience with that? Do you find that counsel, are allies of the mediator? If the case has got some weaknesses, that they actually can work with you, or is this something where you're having to sort of come in and provide a completely fresh perspective?
I think a benefit of the mediation is sometimes you do. The client does on both sides get a fresh perspective. I have seen situations, and obviously I won't get into the details, but where I have had a follow-up conversation after an impasse because I felt strongly that both sides were talking past each other. And after 8 or 9 hours in a mediation, I was scratching my head how it was in either party's interest to continue to incur fees in light of what I had heard. And, in that circumstance, you can call counsel up and have a call with counsel about whether there's anything else that you can assist them with. And be direct and say, I don't see, in light of what I heard, how your client's going to be happy if this goes all the way to trial.
Yeah, Vincent, is that your experience?
Yes, for sure. The mediator is supposed to be the adult in the room. That's why you bring a mediator in. I can't tell you how many times I've seen the situation where the lawyer will say, I really need someone to talk to my client rationally about this because my client has unreasonable expectations. And I represent this client a lot, and I don't want to appear to be weak. But if you tell her that she has a bad case, that's different than me telling her that she has a bad case. So I think the mediator plays the role of, as I said, the adult in the room. That really speaks reason and rationality to directly to the clients, sometimes at the behest of the attorneys.
So, there's
one has to be careful with that, not to, because it's really important that both sides believe that you're impartial and feel it, not just believe,
For sure.
Yeah.
No, for sure. That's the only leverage that the mediator has is
right.
he or she's impartial, and you bring out the reasons why they should settle instead of going to court. But as soon as you lose credibility, you're gone. You're dead. You really have to establish I feel, a relationship with the client as a mediator in the breakout sessions. They need to trust you and listen to you, which is why former judges like Judge Green, carry a lot of weight. She can say, "I've been on the bench for many years, and I've had cases like this, and this is how they might turn out."
Right, right. So, in the 1980s, if you opened up the classified ads of the Massachusetts Lawyers Weekly newspaper, you would see maybe 2 or 3 mediators listed. And now if you open up the Massachusetts Lawyers Weekly newspaper, you'll see 50 or 100 mediators listing that they're available for mediation. I recognize you're both mediators, but you've also been practitioners as well. How does a lawyer go about choosing a mediator? Is it based on the type of case, the relationship, the sort of the blood pressure? What are the attributes of mediators that lawyers should look to so that both lawyers or all of the lawyers in a case can come to some common agreement that this is the person to engage?
I mean, I think you look for several things. One, you look for somebody who has some actual experience litigating and resolving conflicts, because you need a combination of both. I think knowing how the process really works, whether from the perspective of a lawyer or a judge, is helpful. I think you want somebody who really is neutral and does not have his or her finger on the scale, or their finger on the scale. And I think you want somebody who understands the difference between the role of an attorney advocate and the role of somebody who really is neutral and, to use Vince's phrase, wants to solve the problem.
Yeah, Vincent.
I agree with that. No, I agree with that 100%. I mean, I've been brought into cases, I'm convinced, because one of the parties was an Italian American. And so they thought, well, my client, the Italian American, would listen to the mediator who's an Italian American,
Right.
if he can believe that. But so yeah, you look for a lot of things, and I agree with everything Karen has said. Someone who's neutral, someone who has experience, someone who is a problem solver. And we all know who the problem solvers are and who the litigators are, people who like to just run a case to ground. There was a firm that doesn't exist anymore, and they were famous for running a case to ground and then rolling over and settling at the courthouse steps. You don't want that.
I also think you need some flexibility in scheduling. Like, you need somebody who will be flexible, because a lot of the lawyers and often the clients, business clients, are under other kinds of pressures from their stakeholders. And so some flexibility, and obviously an understanding, the ability to process facts and think about how they fit into a potential resolution is, and you want a good listener. I don't know, as a mediator, you often get stacks of paper that have been filed in court. And then you meet with the clients and you get way more facts and detail, and you have to be able to be really good at sifting out what's important and what isn't, what's relevant.
Boy, I agree. Karen, that comes in most mediations late in the day. When you really get down to the brass tacks, you got to really listen, because now you're to the point where you're finding out what the parties really want and are really willing to do. And that's a magical time for a mediator, and it's a good time for the process too. I once had a mediator say that he wanted to start all mediations at 3:00 in the afternoon, because nothing really happened until after 6 hours of mediation.
The last thing is, I think you want somebody who's very good at memorializing agreements. I mean, different people have different styles, but I think it's best, particularly after being a Superior Court judge, if whomever you have can assist you in being very specific and clear in your agreement. Because I've been a judge in cases where counsel and the parties were in too much of a hurry, and they didn't do that effectively.
That's key. That's a great takeaway. A tip for the unwary is make sure that when you do have the deal, that you paper the deal with enough specificity that there'll be no ambiguities or disagreements continuing on. That's great advice. We're almost at the end of our time. I'm just curious, in terms of your practices, do you find it's better to have a firm end date to the mediation so people can work against the deadline, or do you keep it open-ended where you could say, hey, we'll be here for 23 hours if that's what it takes?
I prefer deadlines, but I'm open to.
Vincent, is that your practice? Well, have a deadline?
Well, unfortunately, the trend is that these mediations sometimes just go on and on and on, especially a complicated business case. You'll make some progress, and then you get to the point where you're not really there, but there are a couple of open issues. Do you want another session? Do you want to do another session? And I agree, Karen. I'm not a fan of that, but it happens. It happens not infrequently.
Right.
So I think that's the trend.
Yeah, my favorite story, not a mediation, but a labor negotiation for a contract, was the management and labor thought it would be a good idea to rent a houseboat and go out onto a river and not come back until they had a deal. It sounded great for the first couple of days, but after the toilet overflowed and they started running out of beer and food, they got a deal really fast right after that. So that's going to wrap up this. Amazingly, our time is up. I want to thank you, Judge Karen Green and Vincent Pisegna, both mediators in the city of Boston. That will wrap up this session of Sidebar. We're going to have another Sidebar podcast next week. Until that time, this is Judge Dan Winslow signing off and saying, do justice. Thanks all.